the interests of society at large. The first applicant has another pending charge pending against him at Buganda Road Chief Magistrate Court, which is part hard. Section 15, subsection 4 of the TIA provides other pending charges as a consideration court should take into consideration in deciding whether or not to grant bail in an application of this nature. In the case of Honorable Alan Sewanyana Aloysius and Honorable Segirinya Mohammed versus Uganda, Masaka Criminal Application number 18 of 2021, Justice Lawrence Tweyanze, while dismissing the application for bail, held that in an earlier application granted the applicant's bail, Lady Justice Victoria Nakintu, based on the fact that they had no other charges pending against them, but at the time of determining the present application, they have charges of murder against them, in addition to those they were earlier charged with. It was therefore submitted for the applicants, for the respondent, that the pending charges against the first applicant are a good ground to dismiss his application since he committed the current offenses while on bail via Buganda Road criminal case number 624 of 2023. In respect to the fixed place of abode, it was submitted for the first and second applicants that whereas the respondent contends that both applicants do not have fixed places of abode because they did not provide land titles or tenants agreements to show the fixed places of abode, and therefore they may not be located or held accountable if they jumped bail. Counsel for the applicant submitted that both the first and second applicants provided evidence on oath by way of 2 affidavits and attached LC1 letters in support by each applicant about their respective fixed places of abode. In the case of the first applicant, he provided 2 locations at Buyinja LC1, Wampeo, Ward, Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, Southern Division, Rukonjiri Municipality in Rukonjiri District. And in the case of the second applicant, the location is Kisigula Village, Cell, Mutundwe Ward, Gombola Sabagabo, Makindye Wakiso District, also within the jurisdiction of this honorable. Regarding pending charges, counsel for the applicant submitted that the second applicant has no pending charges against him, and that the first applicant having a pending charge at Buganda Road Court cannot be used to dismiss the second applicant's application as submitted by the respondent. Counsel further stated that the respondent has not provided any evidence of the stage at which the case at Buganda Road is, or whether in fact the first applicant has been put on his defense or found guilty. That he does not cease to enjoy the constitutional presumption of innocence because he has a pending case. Counsel for the applicant stated that the fact that the first applicant was charged with current offense while on bail in respect of the Buganda Road case cannot be used against him, as it is the same state that charged him that is now using those charges to argue that he should not be granted bail, alleging he reoffended while on bail. Regarding the possibility of interfering with the witnesses and the investigations, counsel for the applicants submitted that in Panju versus Ara, 1973, Volume 1, East African Road Reports at page 282, tell that the allegation of interference with the witness must be substantiated and that such substantiation is not difficult to show. Counsel submitted that there is no evidence that there has been placed before this court by the respondent to show that the alleged strong likelihood of interference with the witnesses or investigations. Counsel prayed that this honorable court finds no likelihood of interference with the unknown witnesses or investigations and dismisses the argument of the respondent. Counsel for the applicant informed court that the sureties had been informed of their duties in respect of bail, which duties they understood well and committed to executing. Counsel further submitted that a proposed surety is required to provide A, a copy of his or her national identity card, and B, an introduction letter from the local council one chairperson of the area where the surety is ordinarily resident, as provided under bail guidelines. Council further submitted that the ages of the sureties, which ranges from 27 to 58, demonstrate adult persons capable of understanding what they are undertaking, and that none is a minor and none is a person of extreme old age. Therefore, all sureties have provided these documents, citing the case of Chigongo Farouk versus Uganda, criminal application number 7 of 2024, cited with approval in Makoha case, where the Honorable Court stated that I firmly believe that this court is, in making its decision, must be cognizant of the socio-economic environment in which justice is dispensed, particularly the informal nature of the employment of the majority of Ugandans, that makes it difficult to possess documentary evidence of capacity to meet monetary obligations. To insist on documentary proof of capacity to meet monetary obligations in the event that the surety is called upon to forfeit the bond is to exclude swathes of the population of Uganda from the opportunity to stand surety for relatives and friends. This would tantamount to discrimination against a section of the society on the basis of their socio-economic class. The courts have long held the view that if courts are to simply act on allegations, fears, or suspicions, then the sky is the limit, and one can envisage no occasion when bail would be granted whenever such allegations are made. Counsel for the applicant submitted that the respondent provided no evidence to rebut the grounds relied on by the applicant in support of their applications. It was prayed for the applicants that this Honorable Court finds that the applicants have each satisfied the requirements in the law and on the applicable facts to enable this Honorable Court to exercise its discretion in their favor and release them from custody on bail on reasonable terms. Determination. 1. That the applicant will appear in court and abide by the bail conditions, and who furnishes security which may be forfeited to the state if the applicant fails to appear in court. Therein lies the main duty of a surety. What is pertinent about sureties is that there must be indication that they have been advised of their roles as sureties. They identified themselves properly and have shown and proved their authoritative relationship in respect to the applicant, showing that they are able to exercise their authority and command appearance of the applicant in court when needed. Section 16, subsection 4, Part B of the TIA and paragraph 13, 1 of the Constitution, Uganda, Supra, while acknowledging the release of one accused person on bail is premised on the right to liberty, there should be peace and safety of the people and their property. The court of law and all other organs of government have a duty to ensure that national and international security is preserved. Therefore, the fundamental rights of the individual must be balanced with this greater public interest. In this regard, court has to consider whether there is justification to interfere with the accused person's right to liberty pending his or her trial. The circumstances of the present case are that It is alleged that the offences were committed by the accused persons in various jurisdictions, including Kenya, Greece, Belgium, and Netherlands, with other persons still at large. The investigation into the charges against the applicants have not been concluded. By the fact that the offences are alleged to have been committed in various jurisdictions, investigations are unlikely to be wrapped up as speedily as investigations in respect of offences alleged to be committed only in Uganda. It was urged for the applicants that their continued incarceration, while investigations which do not have a clear timeline of conclusion are ongoing, is prejudicial to them, as it is not clear when the investigations will conclude, to facilitate the committing of the applicants for trial to the High Court. Council for Guidelines for Courts of Judicature, Practice Directions, provides that in considering whether an accused person is likely to abscond, the court shall consider whether the accused has sound sureties within the jurisdiction to undertake that the accused shall comply with conditions for his or her bail. Guideline 15 of the bail guidelines sets out 1. Factors that the court shall take into account in determining the suitability of a surety: age, work, and residence address, character and antecedents, relationship with the applicant, and any other factor court may deem fit. 2. Documentation in respect of a surety that must accompany an application for bail include a copy of the national identity card, passport of alien identification card, introduction letter from the LC1 chairperson of the area where the surety is ordinarily resident. The applicants in the affidavits in support of the application aver that they have sound and substantial sureties who have fixed places of abode within the jurisdiction of this honorable court, and in the event that they are granted bail, they undertake to ensure their compliance with all the terms set by this honorable court in the event that the applicants are granted bail. The first applicant presented 4 sureties as follows. 1. Honorable Semujunga Ibrahim, a 52-year-old male, member of Parliament of Kira Municipality, a resident of Boyogere Division, Kira Municipality. Honorable Semuju is the first applicant's close friend. On file, an introduction letter from the chairperson LC1 of Castle Cell, Kirinya Ward, Boyogere Division, Kira Municipality, indicating that Honorable Semuju is a resident of his area of jurisdiction, and a photocopy of Honorable Semuju's national identity card. Honorable Semuju presented his original national identity card for court inspection. 2. Honorable Muhindo Harold Tone, a 52-year-old male adult, member of Parliament for Bukonzo County East, a resident of Katale Busaula, Chengera Town Council. Honorable Muhindo is the first applicant's close friend. On file, an introduction letter from the LC1 chairperson of Katale Busaula Cell, Chikajo Ward, Chengera Town Council, Wakiso District, indicating that Honorable Muhindo is a resident of his area of jurisdiction, and a photocopy of Honorable Muhindo's national identity card. Honorable Muhindo presented his national identity card for court inspection. Photocopies of the documents are on record. Honorable Francis Mujuche, a 41-year-old male adult, member of Parliament for Buhwejo District, a resident of Rutete Kelezia Cell, Masoli Ward, Kasanga Town Council. Honorable Mujuche is a close friend of the first applicant. On file is an introduction letter from the LC1 chairperson of Rutete Masoli Kelezia Cell, Masoli Ward, Kasanga Town Council, Wakiso District, indicating Honorable Mujuche is a resident of his area, and a photocopy of Honorable Mujuche's national identity card is on record. Honorable Mujuche presented the original of his national identity card for court's inspection. For Honorable Kamara Nicholas Thaddeus, a 50-year-old male adult, the MP for Kabale Municipality, a resident of Buye, Chigowa LC1 Bukoto 2 Parish, Nakawa Division. Honorable Kamara is a close friend of the first applicant. On file is an introduction letter from the LC1 chairperson of Buye, Chigowa 1 LC1 Bukoto 2 Parish, Nakawa Division, Kampala, indicating that Honorable Kamara is a resident of his area, and a photocopy of Honorable Kamara's national identity card is also on record. Honorable Kamara presented the original of his national identity card for court's inspection. Although I find that the applicants have satisfied all the relevant requirements for grant of bail, such as proving that they have fixed places of abode, have substantial sureties, are first offenders with no criminal record, and are of advanced age, the application for bail is denied for the following reasons. 1, the charges against the applicants are among the gravest, if not the gravest, on our statute books. The offenses are alleged to have been committed in various locations in Uganda and in other countries, requiring more time and resources to conclude investigations than is normally the case in offenses alleged to have been committed only in Uganda. Owing to the fact that the investigations are ongoing, the interests of justice at this point indicate that the application for bail is denied on this occasion because there is a likelihood that the applicants, if released on bail while investigations are ongoing, owing to the grave nature of the offense, may fall prey to the temptation to interfere with the investigations. Signed, Rosette Comfort Kania, Judge, 11th April 2025. We shall overcome. We shall overcome someday. In my heart, I do believe we shall overcome someday.
Not be exercised otherwise, which did not happen in this case. We are saying the antecedents on a similar charge before do not support the finding of this court today. That you've had a person being released on a similar charge before, and he has not interfered with evidence. There's no evidence that he has ever even attempted. So that is our take on it. We are going to receive further instructions, and we shall.
It's a dark moment for us. It's a dark Friday for us. Not only the Dr. Chiza Besigye team or the individuals, Dr. Besigye and Obed Rutale, but for the entire country and for our jurisprudence. This is a terrible, terrible decision. It's a terrible precedent. aside, away from the rights of Dr. Kizza Besigye and Obed Lutale, for the jurisprudence of this country, it's a terrible one, because it has upset our jurisprudence on the right to bail, more or less having an effect of overturning the foundation of our Constitution and the foundation, or rather the bedrock, of our criminal justice system. That is the presumption of innocence. In other words, the judge has condemned Dr. Kizza Besigye before trial, because you cannot allege that he committed offenses in Greece, in Switzerland, in Kenya, and that this is a grave offense, and therefore is likely to interfere with the sureties or the investigations without any scintilla of evidence, so without the state coming up with the, comparing evidence to that effect. This is really very, very disturbing. It's baffling. The reasoning advanced even defeats logic. Dr. Besigye, and in the judgment you have heard, she has severally quoted Dr. Besigye's cases where he has previously been charged with the same offenses: treason, terrorism, rape, and what not. And these are all grave offenses. And in all those offenses, he was admitted to bail. So what is so exceptional about this particular charge? It's, we are even short of words, because the cases she has been referring to, where Dr. Besigye was charged with the same grave offenses, he was admitted to bail. And she has recognized that actually he never jumped bail. And in all those cases, he never interfered with the sureties or the investigations, rather with the witnesses. He never in any way or at all interfered with the investigations. She has also recognized the fact that he has been on remand for over 120 days. And the investigations have not been concluded, and they have not even made any summary of the case to be presented to the High Court for trial. In other words, actually there is nothing that is going on as far as investigations are concerned. The time they have had since 16th November last year was sufficient for them to conduct the investigations exhaustively and assemble whatever they wanted to present before court for trial. So it's the reason we feel disturbed, we feel disillusioned, and in as much as we respect the judge and the decision she has made, we take exception to the same. We are aggrieved by that decision, and we are retreating to our chambers. We are regrouping as lawyers to chart a way forward, to explore other available options, because as you have heard, we canvassed each and everything. All the arguments one could present were canvassed in this particular case. You heard, she adumbrated everything, all the arguments, the plausible arguments that we presented. And now we have to explore other options. Of course, since this is a matter of exercise of discretion, an appeal may be out of question. There are precedents to that effect, that a decision in exercise of the High Court discretionary powers may not be amenable to appeal. So it may not be appealable as of right or in any way. But there are other options under the law which we are trying to explore. From here we are going to have a meeting and see the options available, including seeking for redress from other jurisdictions away from here, including the East African Court of Justice and others, which I may not mention here. But now, the decision is taken. We've got to explore other options away from the jurisdiction of this country. In a nutshell, this is a political decision. It's not a judicious decision. It is not a judicious decision. In other words, it's injudicious to deny somebody rights which are guaranteed under the Constitution on such flimsy grounds. It's injudicious. So it's not guided by law. The decision is not guided by the tenets or principles of justice, but obviously influenced by other extraneous matters which are political in nature. That's all I can say in summing it up. It's a decision influenced by extraneous factors which are political in nature, as opposed to matters of law, as opposed to the tenets governing dispensation of justice. That is the summing that I can give. Decision eno etwewunyisiza nnyo oba ensalawo y'omulamuzi si ya mateeka. Eno si ya mateeka. Ebyamateeka byonna tubiwangudde. Era nga bwe muwulidde bwannyonnyodde, ground zonna ez'amateeka tuziwangudde. Ground gye tuluuzinze yeri political. Era gyatasobodde nakunnyonnyola. Kubanga mu kyamateeka agambye Dr. Besigye baamuggulako emisango egyo gyonna gye gimu nga gino lubereberye. Baamuggulako emisango gya treason oba okulya mu nsi olukwe, si gwe gusoose. Baamuggulako emisango gya terrorism eky'obutujju. Ne bamuggulako n'ogwa rape. Gye emisango eminene gisingayo mu Uganda. Naye gy'emisango egyo gyonna ne bamuwa bail. Era ekyakikkiriza. Ndowooza emirundi gyakwotinze keesi ya Dr. Besigye mugiwulidde. N'addamu era n'agamba nti era ne bamuwanga bail, obukwakulizo bwonna bwe bamuwanga yabutuukirizanga. Teyadduka, teyakola ki, n'abeerawo, era tebamusingisangako musango na gumu. Ne gye bamuwa bail gyonna gwakyaliko ku Buganda Road era n'akomawo. N'agamba Surety bonna bali substantial. N'agamba naye yennyini alina permanent place of abode. Naye yennyini muntu wa buvunaanyizibwa Dr. Besigye ne Obed Lutale. Naye n'amaliriza nga agamba naye yadde ebyo byonna weebiri, naye olw'obunene bw'omusango ayinza okutoloka oba ayinza okutaataaganya okunoonyereza. Naye ng'akimanyi bulungi nti n'emisango gye baamuwaako bail before gy'abadde akwotinga baamuwa bail era teyataataaganya bujulizi. Mu nkola yaffe ya criminal justice system, actually ya justice mu Uganda n'ensi yonna, omusango mukadde gwe gusala omupya. Gye tuyita precedent. Kakati abadde alina okugoberera ensala enkadde ate ng'eri ku Dr. Besigye yennyini naga ono yennyini ye yaleeta precedent egamba nti omusango naye guba munene mutya omuntu afuna bail. Era n'agamba nti ono yennyini yali aweereddwako bail neyeeyisa bulungi era tumuwadde bail. Kakati ekyakikyusizza ensala eno mu bufunze ya byabufuzi si y'amateeka. Ensonga zasinziddeko okumma Dr. Besigye twagala okukiggumiza. Ensonga zasinziddeko okumma Dr. Besigye bail si z'amateeka. Ez'amateeka zonna zibadde zita Dr. Besigye. Ensonga kwasinzidde obugaano muta za byabufuzi era zeeraga lwatu mu nsala ye. Ekirala nti judgment eno ya bulabe nnyo. Actually ekyusizza foundation omusingi gwa ssemateeka yaffe. Ega nti omuntu yenna n'omusango naye guba munene gutya okutuusa nga amaze okuwozesebwa n'asingisibwa abeera innocent aba talina musango. Naye mu maaso g'omulamuzi Rosette Comfort Kanya, Dr. Besigye wa bulabe eri security ya Uganda alinga amusingisizza omusango. mu maaso ga Rosette Comfort Kanya Dr. Besigye asobola okugenda Greece, asobola okugenda Switzerland, asobola okugenda Kenya n'ataataaganya obujulizi nga ne passport ye bamujjako. Omuntu yenna kye yalikoze omulamuzi obwenkanya buwalirabye ng'ekyo kyasobola okukola muteekeko obukwakulizo. Yali mugambye tajja kufuluma bweru wa ggwanga okujjako nga kooti emukkiriza. Maybe kye yaligambye nti atojja kugendayo naddala mu nsi ng'ezo ze bagamba ewayinza okubeera abajulizi titojja kgenda Greece, tojja kgenda Switzerland oba tojja kgenda Kenya okutuusa ng'omusango guwedde. N'oteekako obukwakulizo bwe butyo. Naye togamba bugambi nti ajja ku interferinga mu bujulizi n'ennoonyereza ate ng'emisango giri bweru wa Uganda ate nga ye ali wano mu Uganda. So ekyo tekyaddinga kye tugambe kidefeatinga logic. So omusango ensalawo eno ya bulabe nnyo nga bwe mbagambye eri jurisprudence yaffe ku bail. Kuba luli kibadde nti omusango ne guba munene gutya nga basobola okuwa bail. Ono omulamuzi akikyusizza aga nti singa omusango kati guba munene nga treason oba terrorism oba rape, kooti tejja kuwanga bail. Ekyo kya bulabe nti kizibu kati kooti okuwa bail ng'omusango gwa treason kuba y'ensonga yokka gyawadde nti omusango munene. Ate nga amaze okukiraga nti yakamala ennaku ezisukka 12 ku remand. Dr. Besigye n'Obed babakwata 16 November last year. Ekyalibadde kimumala n'omumala ogamba nti obudde obwo bubadde bumala state okumaliriza investigation zaayo. Kubanga bw'oba watandika mu 16th November last year okunoonyereza, kati tuli mu April, kiekyo kiba kyanoonyereza ekitaggwa. So kyalibadde kiwedde akaseera kano. In fact zezaalwadde n'ensonga gaga nti state ebadde n'obudde obumala obunoonyereza n'olw'ensonga eyo tumutadde. So tuli bennyamivu nnyo, tuli banyiikaavu olw'ensalawo y'omulamuzi eno etali ya mateeka naye ng'ate ya byabufuzi. Tuli banyiikaavu okuba nti jurisprudence waffe oba amateeka agakwata ku bail gakyusibwa omulamuzi. Tuli banyiikaavu nti ssemateeka ayisiddwamu olugaayu kuba kakati right to bail efuuse enzibu okusinziira ku decision eno, era state egenda gikozesa nnyo mu misango mingi egy'ebyobufuzi. Bagenda gikozesa nnyo kye bajja okukolanga kuggulako treason, terrorism nga baga gwe oli layikira okuinterferinga with evidence oba n'abajulizi oba ne investigations therefore tukumye bail. So eno judgment egenda kutusiba ffenna, egenda kusiba bangi ab'ebyobufuzi ya bulabe nnyo. N'olw'ensonga eyo tulina okugirwanyisa si lwa ku Dr. Besigye yekka, ye muvumu nga bwe mulabye, naye tulina okugirwanyisa nga tetukomye wano wokka Uganda. Tugenda kuddayo okutuula era oluvannyuma tugenda kufuna meeting tusalewo butya bwe tunoonya ku bwenkanya obutuweebwa mu mateeka ag'ensi yonna, kuba tebikoma wano Uganda. Waliwo kooti eya East Africa, waliwo kooti y'olukalu lwa Africa, waliwo ne kooti endala. So tugenda kutuula tulabe bwe tufuna obwenkanya ewalala, yadde nga na wano tukyagenda mu maaso n'olutalo lwe lumu, naye tulina okufuna justice ebweru wa Uganda mu jurisdictions endala.